Hi, my name is Elizabeth Blandon from Blandon Law, and I'm here to answer the question whether a U.S. citizen needs to be living inside the United States in order to petition a family member, whether that family member is a brother or a sister, or that family member is an adult child, married or unmarried, or whether that family member is a parent. Now, it's important to understand that becoming a resident based on a family member's petition is a two-step process. The first step is the petition. It's Form I-130. The second step, however, depends on where the family member is at the time that the residency is available. If the family member is outside the United States, then the process ends with an interview at an embassy or consulate abroad with the Department of State. But if the family member is inside the United States at that moment, then it's done through a process known as adjustment of status with immigration. Family member might be in the United States, for example, with a work visa. Now, because because of something known as preference categories and priority dates, which we've discussed in other videos, take a long time, I recommend that the U.S. citizen give a mailing address in the United States on their petition. That can be the address of their U.S. attorney, or it could be another family member. But importantly, at the time of filing the petition, the U.S. citizen does not have to be living in the United States. This is, again, as I explain in other videos, because perhaps a U.S. citizen will petition for a brother or a sister, and that residency won't be granted until maybe 10, 12 years later. So you don't know, the U.S. citizen may not know whether they're going to be living outside the U.S. the entire time. So I recommend giving a U.S. mailing address, even if at the time of filing the petition they are not living in the U.S. Now, at the time that the priority date is available, at the time that the family member is eligible to become a resident, it is important for the U.S. citizen to either already be living in the U.S. or to have the intent to live in the U.S. and have a U.S. address. This is so because of something known as the public charge. A foreign national cannot become a resident of the United States, cannot get a green card, if there is a possibility that they will become a public charge to the government of the U.S. And one of the ways to protect against this is that the petitioner has to sign a document known as an affidavit of support. It's a contract between the U.S. citizen petitioner and the U.S. government. Importantly, there are joint sponsors and other ways of getting around it, but the U.S. citizen petitioner will need to sign this. And of course, you can't have a contract with somebody who's not even living in the United States. So if you are a U.S. citizen and you wish to petition your family member, you can do it even though you're outside the U.S. However, importantly, at the time that your family member wants to become a resident, at the time that the priority date becomes available, at that time, you should be living in the U.S. or have the intent. And here at Blandon Law, we can help you demonstrate that. We do it all the time, and we're looking, as always, to inform and protect our clients and also open the door to their success.